Welcome to the 47th lecture in this lecture series on international investment law. In the last two lectures, we had looked at two sets of provisions on dispute resolution in investment treaties where India was a party. In this lecture, we discuss an important principle in international investment dispute resolution known as the principle of local exhaustion. Before discussing the topic, it would be useful to provide a brief background to the dispute resolution provisions in typical VITs, such as the India-UAE VIT of 2013. Please recollect that in lecture 45, we saw that there were three alternative modes of arbitration envisaged. The first one was with ICSID if both states were parties to the convention. The second was ad hoc arbitration under the UNCITRAL arbitration rules. And the third mode was dispute resolution in the courts of the host state. And that once the choice was made, it was final and binding on the investor. This, this type of clause is known popularly as the fork in the road clause. The principle of exhaustion of local remedies simply requires the investor to adopt the third mode first and then go for the remaining modes of dispute resolution as applicable. In other words, the foreigner who has been injured by a state should seek redress with the legal remedies available in that state and then only go for resolution through diplomatic channels or invoke jurisdiction of international tribunals. This principle, popularly known as ELR, is a part of customary international law. For instance, Article 14 of the International Law Commission's draft articles on diplomatic protection of 2006 provides a state may not present an international claim in respect of an injury to a national or other person referred to in draft Article 8 before the injured person has, subject to draft Article 15, exhausted all local remedies. In the Interhanden case, that is Switzerland versus USA, the ICJ, that is the International Court of Justice, held the rule that local remedies must be exhausted before international proceedings may be instituted is a well-established rule of customary international law. The rule has been generally observed in cases in which a state has adopted the cause of its national whose rights are claimed to have been disregarded in another state in violation of international law. Before resort may be had to an international court in such a situation, it has been considered necessary that the state where the violation occurred should have an opportunity to redress it by its own means within the framework of its own domestic legal system. Now, unlike in customary international law, ELR used to be an exception in international investment law till a few years back. ELR is now slowly gaining traction with countries such as India, Argentina, Romania, Turkey, UAE, and Uruguay, as well as many African countries adopting it in their model VITs. However, a vast majority of investment treaties in force do not contain the ELR. For instance, the Convention on the Settlement of Investment Disputes between States and Nationals of Other States, that is the ICSID Convention, states in Article 26 that consent of the parties to arbitration under this convention shall, unless otherwise stated, be deemed consent to such arbitration to the exclusion of any other remedy. A contracting state may require the exhaustion of local administrative or judicial remedies as a condition of its consent to arbitration under this convention. Here, you must note that the first line talks about deemed consent to such arbitration and the exclusion of any other remedy, including a local remedy. However, a contracting state may also require, so this that may require is permissive in nature. Therefore, under the convention, the default provision is for the waiver of ELR and deemed consent to arbitration. Some of the older VITs used to provide for local exhaustion expressly. For example, Article 4, Sub-Article 2 of the Germany-Israel VIT of 1976 provided the legality of any such expropriation or nationalization and amount of compensation shall be subject to review by local judicial remedies. Article 7 Subarticle 2 of the Romania-Sri Lanka BAT of 1981 provided as a precondition for ICSID arbitration as, however, each contracting party hereby requires the exhaustion of local administrative or judicial remedies as a condition for its consent to conciliation or arbitration by the center. Center here being the ICSID. Even as recent as in 2007, Article 8, Subarticle 2 of the Albania-Lithuania BAT of 2007 provided if such a dispute cannot be settled amicably within 6 months from the date of the written notification provided in paragraph 1 and the domestic, judicial and administrative remedies have been exhausted, the contracting party or the investor shall be entitled to submit the dispute to arbitration. So consent to arbitrate is considered as a waiver of ELR. Some treaties provide this expressly or they even expressly waive the ELR. So what are the implications of absence of such conditions in a treaty? Where the treaty is silent, there is a deemed waiver of the ELR, as was held in Lanco International versus Argentina in the year 1998. This was rendered in the ICSID context. In the non-ICSID context, the arbitral tribunal held in Mytilinios versus Serbia and Montenegro in 2006 as follows. The result that BATs granting private investors direct access to international arbitration do not require local remedies to be exhausted is also confirmed by underlying policy reasons. A requirement for the exhaustion of local remedies as a general precondition to mixed investment arbitration would seriously undermine the effectiveness of this form of dispute settlement. The Mytilinios Tribunal also held that reading into an EIR into the treaty of ELR when the treaty is silent made the fork in the road clause redundant. It stated to assume that the BAT had not tacitly dispensed with the requirement to exhaust local remedies would imply that an investor, before making his or her choice between domestic courts and international arbitration, would have to exhaust domestic remedies. This would, in effect, render the domestic courts alternative in the fork in the road clause meaningless, and thus such an assumption cannot be made. On the contrary, a fork in the road clause obliges an investor to choose whether to pursue remedies before domestic or international fora. Once the choice is made in favor of domestic remedies, international arbitration is no longer available. Thus, one can require the exhaustion of local remedies as a precondition for access to international arbitration. Instead, the initiation of local proceedings forfeits access to international arbitration. That's all in today's lecture. Have a good day. More on local exhaustion in the next lecture.